Good evening, ladies and gentlemen. I hope that you can hear me. I don't care as much as if you can see me as I do if you could hear me. We have begun. I think we have all our technological issues worked out. Thank you, David Hagar, who owns Beyond Innovative Technologies and Consulting. David Hagar has worked for free, tirelessly. Hopefully, we are delivering this to you tonight. And Joanne Woodard, whose really persistence and vision got this launched. I have taught these classes in the past, but never online, and I was not thinking of doing it again until Joe came to me and asked me if I wanted to. We are all donating our time, and we are donating our time because we love our country like you do, and because we're concerned about what's going on, and because we think it's important for knowledge, particularly about our Constitution, to be imparted. And I compliment you for giving an hour of your time on Sunday evening. I know that we all have family obligations and other things, so I compliment you for being a part of this. I hope that you will take notes tonight. I'm going to emphasize certain things, and we will build on this knowledge as we go through the course. I'm proud to tell you that there are people calling in. We're in Shreveport, Louisiana. I expected, hopefully, we'd have Louisiana people calling in, but we also have people from California, Tennessee, Mississippi, Texas, Alabama, Arkansas, Florida, and North Carolina. And that's all that I was able to write down very quickly. So I'm excited. I think I have a couple of law school friends who are on the phone, on the webinar. Marla and Vicky, if you're on, it's so good to be in touch with you again. Please be easy on me. Those ladies had all the same classes I had. Regarding the webinar, all I want to say is David and Joe and I are all donating our time, working absolutely for free. If you wanted to donate so we can pay strictly for this webinar, you can do so. We're going to get Zelle and Venmo put on our system so you can do Venmo and Zelle. But also in the meantime, you could write a check to Royal Alexander, but in the notation line, I ask that you write Constitutional Revival. And it's going to go into one bank account devoted only to that. And we're going to use it strictly to pay for these webinars because the webinar people aren't doing this for free. They are the first night, and we appreciate that, by the way, webinar people, for letting us have the first night. As we go through the material, I'm going to drill down in certain places, but I'm not going to be able to drill down in every place, or we'll never cover the material that I would like to cover. So again, please take notes. If you have a question that I can't get to, and you'll be surprised how quickly 50 minutes goes or this hour expires. But if you have any questions, we have an account just for this session, for this program, constitution.royalalexander@gmail.com. constitution.royalalexander@gmail.com. And by the way, I didn't finish. If you want to write a check, again, Royal Alexander, make it out to, in the notation line, Constitutional Revival, and you can send that to P.O. Box 1837, Shreveport, Louisiana, 71166. Again, Royal Alexander, Constitutional Revival, P.O. Box 1837, Shreveport, Louisiana, 71166. And again, those contributions will be used only to keep us on the air. I know that's not the correct description, but that it seems like we're on the air to me. Gang, there is a lot going on in our country right now. A lot of things we really haven't seen for a long time all at once. Maybe never exactly as things are going on daily in America. We all remember the 60s. Many of us remember the 60s. We had the Vietnam War going on. Two of the Kennedys, the president and his brother RFK, were assassinated, as was Martin Luther King Jr. There was huge anti-war protests. There was all sorts of public statements, what looked to be chaos at the time. And so our country has been through these things before. The one thing that we have to restore, of course, is law and order, but we have to follow what our Constitution prescribes. And our state governments and the president have to follow what it allows and has to not follow what it doesn't allow. as you know, our framers meticulously and painstakingly put together our Constitution in that very hot room, that hall in Philadelphia, where they had to keep the doors and windows closed. They already didn't have air conditioning, but they were only supposed to be there to revise the Articles of Confederation. They sure weren't supposed to be there to write a new Constitution, and they knew that. So they had to keep it secret, essentially. And so they kept the doors and the windows closed every day. And in those clothes they wore at the time, with no air conditioning and no breeze, can you imagine how uncomfortable they must have been? They did that for almost 5 months. And the conclusion and the product is what I think is a divinely ordained document. I think God's hand was on those men who stayed there, fought through it. Many of them came and left during the convention. Again, they were only supposed to be revising the Articles of Confederation. So that is what we're going to take on. I'm going to add some historical analysis as we go. I was going to start with the Declaration of Independence, as you saw on the syllabus. We'll just call it syllabus. But it occurred to me, there have been some recent Supreme Court decisions that might have had a number of us wondering, maybe we disagreed, but wondering how could a justice have arrived at this particular conclusion? And so I thought I would begin, and then in a little while, we'll get to the Declaration of Independence. And I want to say, if I don't remember to say it then, the Declaration of Independence is considered the promise our new country made. And the Constitution is considered the fulfillment of that promise. The Declaration of Independence is considered the promise, and the Constitution itself is considered the fulfillment of that promise. Okay, but we're not going to do the Declaration just yet. We've had Supreme Court justices, of course, almost since the beginning of time. One of whom, my good friend and law partner Craig Smith reminded me of recently, was Marbury versus Madison. Marbury versus Madison is a decision that in and of itself was not particularly a landmark decision. In fact, it wasn't. But what Chief Justice John Marshall wrote in Marbury versus Madison has been hugely impactful in our country's history. Why? Why do I say that? What about Marbury versus Madison? There is one line. It's fabulous reasoning, even if you don't agree. And that's another thing. I'm not trying to persuade you. Look, I am a conservative. I consider myself a constitutional conservative, but I have great respect for the Constitution itself and the cases that have developed it, and for the Declaration of Independence. I will feel like I've done something of value if you come away with a sense of how to analyze what the Supreme Court has done. In fact, what any judge has done, but particularly the Supreme Court. So when I go through this, I may occasionally state what I think is correct or incorrect, but that's not the point of this. The point of my doing this program is because I want you to understand the analysis that the Supreme Court uses and has used for 240 years, or right at 240 years, to decide what the words of the Constitution mean and what the words of federal statutes mean. So right now, we're doing constitutional interpretation. And what we're doing right now, I want you to be proud of yourself and know that if you were in law school, and in particular you were in a constitutional law 1, con law 1, or con law 2 class, this is what you'd be doing. So I want you to know that you're getting a taste of law school here. There are two types. There's many variations of this, but there are two principal types, two most well-known, most commonly used types of statutory interpretation or judicial analysis. It's called a bunch of different terms, and I'm sure use them interchangeably. They are what I call, number one, judicial activism or loose constructionism, and number two, strict constructionism. So if you're taking notes, when I repeat things, it's because I want you to hear them clearly, and because if you're writing, I want you to make notes. These are the two ways that are most commonly known and most commonly used, although there's variations of each. we could spend all night just on that topic. But the two main ones that are used today and have been used by justices for a long time are, number one, judicial activism / loose constructionism, and number two, strict constructionism. Okay, so if you're taking notes, I hope you'll write that down. All right, number one, judicial activism or loose constructionism. What is it? In the simplest term, judicial activism, loose constructionism, is the view that the Constitution is a living organism. It, to these justices and to legal scholars, it's a living organism that has a dynamic meaning that's always evolving and adapting to new circumstances without being formally amended if it's the Constitution, or without having the Congress change it if it's a federal statute. That is judicial activism / loose constructionism. This living organism, and I'm giving a fair reading to the people who, there are justices who are very bright, who think this truly is how you're supposed to read a statute. I don't agree, but they do. And Royal is not on the Supreme Court. And I also wasn't a member of Congress at the time any of these federal statutes were passed. So I'm an observer just like you are. Judicial activism and loose constructionism. The view is the Constitution is a living organism that has a dynamic, evolving, adaptive meaning, always to new circumstances, like whatever cultural or changes or social mores are in fad or in vogue in the United States now. That's what the justices who subscribe to the judicial activism, loose constructionism view would say, you know what? I know what's going on in the United States. I know what's going on. I know what my life experiences are. And so I'm in a good position here on the Supreme Court, one of 9. Of course, they're unelected and they're life tenured. They're unelected. They're appointed by the president and they're life tenured. They never leave. So federal judges are very powerful. And of course, US Supreme Court justices are particularly powerful. But if you think being judicially active, and they truly believe it, Justice Sotomayor made the comment one time that the court needs a wise Latina. I know she believes that. I know she believes that her life experience, everything she's been through in her life, will contribute to helping her make the best interpretation of laws. I think that that's risky. I think that's dangerous, because then we're simply trying to nominate people to the US Supreme Court who have a particular view of life. You want enough views of life. That view of interpreting law may work in other countries, but it's absolutely not what our framers, the framers of our Constitution, had in mind. In my view, that view of judicial activism / loose constructionism, where the justices plug in here in 2020 what they think people want here in 2020. And that's a problem, because the Constitution was written 240 years ago. And now many of these federal statutes are over 200 years old. And I promise you, the views when they were written, both federal statutes and the Constitution, and what's going on in America in 2020 are vastly different, vastly different. So I think it violates the separation of powers. Keep in mind, we have judicial, legislative, and executive. All three of our tripartite form of government, all three branches have to stay in their own lane. I mean, that's really the simplest way I know to put it. The judiciary, the legislative branch, Congress, the US House and the US Senate, and the president, all three have to stay in their own lane. And I think with loose constructionism, with judicial activism, the Supreme Court is coming out of its lane and it's going over into the Congress. It's legislating. I think when the Supreme Court is doing anything other than interpreting the plain meaning of words at the time that the Constitution was written or that the federal statute was passed, those members of Congress, if you're looking at anything besides that, I think you're legislating. I think you're not judging. And so that's why I always think there's a real problem with judicial activism, because everyone has different life experiences. Our law has to be tied to something more dependable than just every new justice's life experience. That's why we have precedent. That's why we have long lines of cases, which with, stare decisis, the decision will stand. Precedent means it gives predictability to our society, knowing, well, this is the body of law the Supreme Court has followed on down the line for 240 years, and we can rely on it as a society. When you've got a new justice who comes in saying, I don't really care what those people thought 200 years ago. I think I know best. I think that's judicial arrogance, and I also think it's just wrong from a standpoint of constitutional and statutory interpretation. So that's judicial activism. The second major school of thought, judicial philosophy, is called strict constructionism. So I know you wrote down judicial activism and loose constructionism, and now number two is simply strict constructionism. What is strict constructionism? It most prominently includes the disciplines of textualism and originalism. All right, what is textualism? What is textualism? Textualism is simply giving words their plain meaning and nothing more. At the time, originalism, what did they originally intend? Originalism is searching for what the framers meant or what the members of Congress meant when either they drafted the Constitution or they drafted a federal statute. So textualism and originalism. Textualism is simply giving words their plain meaning and nothing more. And originalism is searching for what either the framers meant, their original meaning of the framers, or those members of Congress back whenever that they passed that statute. What is the original meaning? That is what originalism comes from. I want to share something with you that, and you don't have to disagree with any of my views, of course. I want your respect and faithfulness to be for the material, for the Constitution and the cases. But Justice Scalia, who, as many of you know, even if you disagreed with him, he had an inimitable way of stating things. And he wrote a couple of books about how to do statutory interpretation or constitutional interpretation. He said at a speech, and then repeated it many times after, Justice Scalia said, quote, "The Constitution is not a living organism. It's a legal document, and it says what it says, and it doesn't say what it doesn't say." Justice Scalia again. The Constitution is not a living organism. It's a legal document, and it says what it says, and it doesn't say what it doesn't say. And he was one of probably the most prominent strict constructionists. He was a textualist. He was an originalist. He wanted to give the words their plain meaning. He wanted to know what the framers were thinking and what the people in Congress were thinking when they passed a statute. So keep that in mind. He would have been the first to say that it's not the role of my court to legislate. He said, again, our federal state system, our system of co-federalism, as we talked about, judicial, legislative, and executive. But the federal government vis-a-vis the states is a system of co-federalism. And the two are absolutely supposed to be co-equals. You might look around the country today and say, it doesn't really seem like they're co-equals. It seems like the federal government is much bigger and much more powerful. And I think you're right, but that's not how it's supposed to be. The federal government and state governments, the 50 states, are supposed to be co-equal sovereigns, neither more powerful than the other. Because if that had not been the case, then I promise you, the people who drafted the Constitution and then those states who agreed, many of them over heated protest, many of those states had people in it like Patrick Henry and others who absolutely did not trust what those men had done in crafting the Constitution when they were supposed to be writing the Articles of Confederation. So we have a tripartite system of government, but we have a system of co-federalism, state and federal. who are supposed to be co-equal sovereigns. The purpose of the court, the purpose of the judicial department is, and I never finished my statement earlier in Marbury versus Madison, John Marshall wrote, and maybe the most important line in all of law, because it created what's called judicial review for the Supreme Court, any court. It created the doctrine of judicial review, that if it gets challenged, if a particular enactment gets challenged, it will come into court and be reviewed by the judge, by an appeals judge, or by the U.S. Supreme Court. That judicial review was created in Marbury versus Madison, and that important sentence, maybe the most important sentence in all of law, is that John Marshall writes, "It is emphatically the duty and province of this court to say what the law is." And I think he said judicial department, not the court. Either way, it is emphatically the duty and province of the judicial department to say what the law is. Now, that may seem obvious. They're the judicial branch. Why wouldn't they be the ones to say what the law is? But what that sentence and that decision, Marbury versus Madison, laid a foundation for is, in many ways, the overarching power that federal judges have today. It can't be overstated, Marbury versus Madison. It is emphatically the duty and province of the judicial department to say what the law is. That one sentence laid the foundation for the Supreme Court, in particular, to review any sort of legislative enactments, any sort of executive orders a president may sign, anything going on in the states, because we know the Constitution was later applied through the 14th Amendment to the states. That sentence, that decision, and then all the cases built on it from then on. So that is judicial review, and it's a powerful tool the courts have. Okay, those are the doctrines of constitutional interpretation: judicial activism / loose constructionism and strict constructionism. And Justice Scalia's view that the Constitution is not a living organism. It says what it says. It's a legal document. It says what it says, and it doesn't say what it doesn't say. All right. And the separation of powers is important because the judicial department, the justice part, the judges have to stay in their lane. The judicial branch has to stay in its lane, just like the president's got to stay in his lane, and the Congress has to stay in their lane. The Congress being the U.S. House of Representatives, of course, and the U.S. Senate. We know that every state, based on its population, has that number of members accorded in the U.S. House of Representatives. But of course, the grand bargain was that in the Senate, every state, regardless of size, has 2 U.S. senators. So Rhode Island, tiny little Rhode Island in the U.S. Senate is just as powerful as California. They both only have 2 U.S. senators. But the bargain was that in the House, we're going to apportion representatives based upon your population. So Florida has about 55 U.S. members of Congress, and I think Rhode Island has 1. I know Wyoming only has 1 because that's all their population, but they still have 2 U.S. senators. So that was the grand bargain. I don't mean to, we're going to eventually get to all that, but if you have questions, make notes. Now, what we just learned about constitutional interpretation. There was a case just recently, and lately there have been a number of U.S. Supreme Court cases that have a couple of them have knocked me back, honestly, results I just didn't anticipate. But since we're talking about how to do statutory and constitutional interpretation, I want to take a case that's about 3 weeks old. And Justice Gorsuch wrote the decision, along with the 4 liberals. It was a 5-4 decision. What's fascinating to me and what I want you to know is the analysis of both sides. We're going to do Justice Gorsuch's analysis, then we're going to do the dissent. And I want you to know, based on what we've talked about, judicial activism / loose constructionism or strict constructionism, how you think the case should have come out. The case, very simply, the facts. Clayton County, Georgia, fired a man named Gerald Bostock. By the way, this decision is called Bostock versus Clayton County. The county of Clayton County, Georgia, fired Gerald Bostock for conduct unbecoming. I'm sure in its county manual, he did something that's inappropriate or unbecoming. A county employee, unbecoming a county employee, shortly after he began participating in a gay recreational softball league. Okay, those are important facts. This man worked for the county and he was fired from his job with the county, Clayton County, shortly after he began participating in a gay recreational softball league. Those facts are important, so please remember them. What we're analyzing this under is the 1964, remember 1964, that's important. 1964 Civil Rights Act, Title VII, okay? The 1964 Civil Rights Act, Title VII, prohibits workplace discrimination based on race, sex, religion, or national origin. Those are four big ones: race, sex, religion, or national origin. You cannot do workplace discrimination. You can't have employees in a workplace situation and discriminate against them based on race, sex, religion, or national origin. Tonight, we're focusing on sex discrimination, okay? The court held, again, the majority, and Justice Gorsuch wrote the opinion, a man who, you all remember his confirmation hearing not long ago, a year and a half ago, maybe now, where he prided himself on closely, strictly interpreting the Constitution, and he thinks he's doing it here, which is why I find this fascinating. The court held, and listen carefully, and we're going to go over this a couple of times, Bostock versus Clayton County. The court held that because sexual orientation and gender identity cannot be explained as traits that someone has without referring to the sex of the person, discrimination based on those traits, on sexual orientation or gender identity, those traits, constitutes discrimination based on sex. I'm going to say it again. This was the essential holding. The court held that because sexual orientation and gender identity cannot be explained as traits that someone has without referring to the sex of the person, discriminating based on those traits constitutes discrimination because of sex. Gorsuch. Now, he ruled it is discrimination, and of course it's prohibited by Title VII of the 1964 Civil Rights Act. 1964 again, remember that. He listened to his reasoning, because if Justice Gorsuch was here with us tonight, I'm sure he is surprised by the criticism he received in the last month from this decision, because I'm sure he thinks he did it just like he was supposed to, just like the man whose seat he took, Justice Scalia, would have done it. I know Justice Gorsuch believes that. This is what he wrote. He claims that he was interpreting the original meaning of the statute enacted on the basis of sex, remember that's one of the four, in such a way that discrimination based on sexual orientation or on gender identity is necessarily also discrimination based on sex. Okay? Now, I want you to think about something. I'm going to tell you that in a minute. Gorsuch concludes, and again, he thinks, listen to this sentence, he thinks he's doing it just like he's supposed to, just like he said he would. Strictly construing words. Justice Gorsuch concluded, quote, judges are not free to overlook plain statutory commands on the strength of nothing more than suppositions, guessing essentially, or guesswork, about expectations that Congress may have had. That's what sounds like the dissent is saying. In a minute, we're going to get to the dissent. But that's the majority opinion. Gorsuch just saying, look, judges are not free to overlook plain statutory commands on the strength of more than suppositions about intentions or guesswork about what the Congress in 1964 might have meant by the word sex discrimination. You see, he's going back to 1964 too, which I promise you is what the dissent is about to do. Gorsuch is saying, so if an employer who fires an individual merely for being gay or transgender, they defy the law because they've discriminated on the basis of sex. Now, here's the example. And it was argued. It was argued by the people who support the majority view. This is Gorsuch's point. Mr. Bostock was a man who joined the Gay Men's Softball League. And that's what the county had a problem with. Because if a woman who worked for the county had joined the Gay Men's Softball League, no one would have looked twice. No one would have batted an eye. That's the argument. It's only because he's a male and he joined the Gay Men's Softball League that the county had a problem and fired him for conduct unbecoming. Whereas again, if a woman who worked right across the hall from Mr. Bostock joined the Gay Men's Softball League, it would have been fine. There would have been no problem. No one would have had an objection, is what I'm saying. So Justice Gorsuch concludes, because y'all wouldn't have had a problem with a woman, the only reason you could possibly have a problem with Mr. Bostock is because he's a male joining a Gay Men's Softball League. That's how Justice Gorsuch reasoned it. And I mean, look, they're all very bright. We don't have to agree with their decisions, but constitutional law, these concepts are, to me, really, you got to focus. I mean, they're really probably some of the most complex in all of the law. That is how Justice Gorsuch justified it. You only fired him because he was a man joining the Gay Men's Softball League, and had a woman join the Gay Men's Softball League, no one would have cared. So you could only be firing him because he's a man, and that's sex discrimination, and it violates this law. That's Gorsuch. Now, listen to the dissent. Justices Alito and Justice Clarence Thomas, in their dissent, argued that the language of the Civil Rights Act did not intend, at the time of its passage in 1964, they're looking back, just like Justice Gorsuch said he did. Justice Thomas and Justice Alito are also looking back to 1964 to know what those members of Congress and the president who signed it were thinking when they used these words. They thought at the time they could not have intended in 1964 to protect sexual orientation and gender identity. Those members of Congress who passed this in 1964 could not have intended to protect sexual orientation and gender identity. Alito and Thomas go on to argue that no dictionary, and they go look at dictionaries. They go find a dictionary from 1964, and they looked up what the word sex means in 1964. Again, Alito and Thomas. They argue that no dictionary from that time included gender identity or sexual orientation as part of the definition of sex. And they rejected Gorsuch's argument that gender identity and sexual orientation discrimination are included in the meaning of the term sex. The opinion says, appealing to roughly contemporaneous dictionaries, either one from 1964 or maybe 1963 or 1965. Right in that time period, they reviewed dictionaries, and all they could find was that the term sex was defined in 1964 as referring to the status as either a male or a female, based on biology. The biological determination that this is a boy or this is a girl. And that's all they meant. Alito and Thomas argued with the word sex. That's all they meant to include. They think Gorsuch went and stretched it to include sexual orientation and gender identity. They're saying that's not what in 1964 the word sex meant. and you're supposed to be looking at the words, Justice Gorsuch, they're saying, and I promise you, these guys, they write beautifully and eloquently, but they don't like being called out. I promise you, in some ways, it probably bothers Justice Gorsuch that it was he and the 4 liberals who made up the 5-4 decision. But I promise you, in his defense, Justice Gorsuch thinks, I'm looking at the word sex. I'm looking at it. But you can't know that those people in 1964 intended to limit it because it just says sex. And as Justice Gorsuch wrote, you can't get to discrimination on the basis of sex without going through someone's gender. And here you picked on the male. He got fired, but had a woman gone to join the Gay Men's Softball League, you wouldn't have a problem. That's what Justice Gorsuch is saying. But Justice Alito and Thomas are saying, no, brother, they call themselves my brother, the brethren. No, Justice Gorsuch. It was in 1964, Alito and Thomas write, it was as clear could be that this meant, the word sex, discrimination based on the genetic or anatomical, our anatomy, characteristics that men and women have at the time of birth. That's all. Boy or girl, man or woman. They were saying in 1964, Alito and Thomas are saying, those people, by discrimination based on sex, would be a clear case like women come to apply to work at an office in any position. And in 1964, the owner of the business says, no, we're just not hiring women. I know you're capable, you're qualified, we're just not hiring women. That is, you'd have to argue straight up sex discrimination, discrimination based on sex. But not this, not this. So they said we've not found a single dictionary from that time that defines sex to mean sexual orientation, gender identity, or transgender status. They say that, again, my point, if sex in Title VII means biologically male or biologically female, which Alito and Thomas think it does mean, then discrimination because of sex means discrimination because the person in question is a male or a female, and that's all. Again, my analogy, I'd like to work for your company. I'm sorry, ma'am, we're just not hiring women here. That's straight up sex discrimination. And not, they say, because a person is sexually attracted to members of the same sex or identifies as a member of a particular gender. That's not what they were thinking in 1964, Justices Alito and Thomas argued. Here's, and again, they write beautifully. I want you to hear the crux of the dissent, the Alito-Thomas dissent. In 1964, ordinary Americans reading the text of Title VII would not have dreamed, their words, that's in the opinion, would not have dreamed that discrimination because of sex meant discrimination because of sexual orientation, much less gender identity. Again, the dissent, the ordinary meaning in 1964 of discrimination because of sex was discrimination because of a person's biological sex, not sexual orientation and not gender identity. The possibility, the opinion goes on, the possibility that discrimination on either of those grounds might fit within some exotic understanding, that's in the opinion, some exotic understanding of sex discrimination would not have crossed their minds. The drafters in 1964, using the word sex in that statute in 1964, they would not have dreamed that this exotic understanding would be used. That is the dissent. Do you see the two different results from, and it wasn't a more liberal justice who wrote the opinion, it was Gorsuch. And I know, to his credit, I know he thinks he's being faithful to true, plain, reliable, trustworthy constitutional interpretation. I know he thinks he did it correctly. But Justices Alito, and again, this is the dissent. It was 5-4, but Justice Gorsuch's majority carried the day. What we've gone through just now is the dissent. But many times later, dissents end up becoming majority opinions. So that's why they make sure and put their dissent down. But they say, just to use terms like exotic, this is an exotic understanding of the word sex, and that people in 1964 would not have dreamed of the word of sex being used like this. So those are the two types of statutory interpretation. I use this case because it's really laid out here, and I wanted you to have a recent example of both their reasoning, because they both sides think that they're doing it correctly. They absolutely do. I disagree with the majority, because I also believe in 1964, if you give the plain meaning of the word sex, that they just weren't thinking of this. But I also understand Justice Gorsuch's argument. He's saying, well, you're limiting what the meaning of the word sex is, because you can't discriminate based on sex until you discriminate based on the fact that someone is gay. And we did it about the gay men's softball league. We talked about that. So those are two classic areas, two classic examples of constitutional interpretation. I want to share Justice Kavanaugh's. He joined the dissent, but he wrote something that I also think is very important. In Justice Kavanaugh's separate dissent, he wrote, we should let Congress expand Title VII. He's focusing again on the separation of powers. Justice Kavanaugh is saying, it's not our job to go fill in the word discrimination based on sex. It's not our job to fill it in. If Congress wants to revise that 1964 act, it can do it. Let it go explicitly write those words in there. Sex discrimination includes sexual orientation, gender identity, transgenderism. Justice Kavanaugh is saying, go write the words in, Congress. We're not doing your work for you. It's not our job. It's not appropriate. It's not legitimate for us, who are simply supposed to read words and interpret them, for you to expect us to do policy here. It's not our job to do policy. You're the elected officials, Congress. It's your job to do policy. So Justice Kavanaugh said, based on the separation of powers, right here, he said, the judicial branch is not staying in its lane. You're coming way over here and you're doing social policy. You're saying basically, in their view, that because sexual identity, sexual orientation, and all that are issues we face in 2020, that somehow we're supposed to stick that into a word from 1964. But both sides believe they absolutely have legitimate grounds, statutory interpretation grounds to hold what they do. And it's fascinating. But Kavanaugh makes the best point. Congress, if you want those words to be included in what sex discrimination means, then you need to tell us. Go tell us. We're not doing your work for you. We're not elected by the people. We don't pass bills. If you want the Civil Rights Act of 1964, sex discrimination, to include this, you need to go revise the statute. So that was Justice Kavanaugh's opinion. All right. Now, I know that was a good amount, but I hope I tied in on it. Golly, time is flying. Doggone it. But I wanted you to understand that. That's how cases get approached. Okay. I'm going to begin. Are we really only going 50 minutes? I have 6 minutes. Look, we're going to do the Declaration of Independence. It's a fabulous document. We know that Jefferson, of course, was the third president. He founded the University of Virginia. He drafted the Virginia Statute for Religious Freedom. But he wrote this document with his quill pen. They gave him 17 days to do it. He was part of a committee. Adams was another part of it. Benjamin Franklin was part of it. But they thought that Jefferson wrote better, so they let him write it. It's beautiful. Jefferson was so brilliant. I have to tell you that one night at the White House, President Kennedy, John F. Kennedy, hosted a dinner honoring Nobel Peace Prize winners during his presidency, somewhere between 60 and 63. President Kennedy invited a room full of Nobel Peace Prize winners to come have a dinner at the White House. And he was so impressed. We know Jefferson did so much. He was so well-rounded. He was such a Renaissance man. Jefferson's interests were in agriculture and farming and birds and machines and biology. He had such a at Monticello, at his home in Monticello, if you've ever been, you see all of his inventions. He was so bright. Here, this room full of bright people, President Kennedy is making a toast. He's making a speech. He's speaking to these Nobel Peace Prize winners. And keep in mind, Jefferson was the third president of the United States. President Kennedy said, quote, "I think this is the most extraordinary gathering of human brilliance ever at the White House, except possibly for when Thomas Jefferson dined alone." Meaning, Thomas Jefferson dining alone here at the White House might have brought more brilliance into this room than all of you Nobel Peace Prize winners. And I thought that was a fascinating description of Jefferson. If I'm going to keep going in case we have more than 4 minutes. Keep in mind, Jefferson lays out beautifully, and we're going to pick this up next time. I'll just move a little faster. Just this one sentence. And then we're going to go into the most profound sentence, probably in all of writing. But the first sentence, when in the course of human events, it becomes necessary for one people to dissolve the political bands which have connected them, meaning we trying to be the new country and you, Great Britain, we want to dissolve the political bands which have connected them with another and to assume among the powers of the earth the separate and equal station to which the laws of nature and nature's God. And there's several references to God in here. And so when I hear people tell me, yeah, the framers, they weren't really that religious. They didn't really have faith in God. We just see that rebutted time and time again. But according to our separate and equal station as a new country we're trying to become, and telling you right now, King George, that we're going to become, to which the laws of nature and nature's God entitle us, a decent respect to the opinions of mankind requires that they, meaning we, should declare the causes which impel us to this separation. Meaning, we understand you're wondering why we're doing this, and so we're going to explain. And I'm going to keep going, and if I get cut off, well, we'll go over it again. But keep that, in the course of human events, Jefferson's saying, when one people decide to dissolve the bands, the connection to another, which have connected them with another, and to assume among the powers of the earth this right we have to be free, and all that's going to come out later, free people to form our own country, our separate and equal station to which the laws of nature and of nature's God entitle us. Great Britain, we're entitled to do this. A decent respect to the opinions of others makes me explain why we're doing it, and he does. We hold these truths to be self-evident, that all men are created equal. That sentence alone, without what's coming next, is profound. It had never been put down in any sort of blueprint of governance in the history of mankind. We hold these truths to be self-evident, that all men are created equal, meaning all people, that they are endowed by their Creator with certain unalienable rights. Unalienable just means they can't be alienated from us. If we're born and infused with a soul, which we are, these are intrinsic rights we have as human beings, part of our human dignity. All men are created equal. We hold them to be self-evident, that they don't even need to be described. We hold these truths to be self-evident. We can see it and conclude that. That's how clear it is. That all men are created equal, that they are endowed by their Creator, yet another reference to God, with certain unalienable rights, rights that cannot be taken away. That among these are life. Does that not make sense? No other right is necessary if you don't have the right to life. Life, liberty, and the pursuit of happiness. Not the promise of happiness, not the guarantee, I should say, of happiness, not the securing of happiness, but the pursuit. We are guaranteed as a fundamental right the pursuit of happiness. And that to secure these rights, governments are instituted among men. That makes sense. Someone has to enforce these rights. Somebody has to vindicate our rights as free citizens. So we form governments. So to secure these rights, governments are instituted among men, deriving their just powers. Their just powers. They have to be just, not illegitimate, not tyrannical, not unjust. They derive their just powers from the consent of the governed. The consent, our consent. A lot of people would say, I don't think the government has my consent anymore. A lot of people in America today would say, the government doesn't have my consent anymore. I don't agree to this form of government anymore. So the government, to be legitimate, has to derive its just, J-U-S-T, short for justice, just powers from the consent of the governed. That whenever any form of government becomes destructive of these ends, it is the right of the people to alter or to abolish it. Once again, we have these inalienable rights given to us by God simply by virtue of our birth. We were born, and with it, we have certain intrinsic human rights. The rights to truth, freedom, liberty, the right to life, here, the right to pursuit of happiness. That's why governments are instituted. But this is a powerful sentence. However, Jefferson says, whenever any form of government becomes destructive of these ends, it is the right of the people to alter or to abolish it. Look at those words. To alter, well, alter could mean we vote old people out of office and vote new people into office. That's certainly altering the government. But abolish, the word abolish is in here. And I think the word abolish, all the way back to Thomas Jefferson's time, means pretty much the same thing it means today. It means to get rid of it. It means to start over. So when government becomes destructive of those intrinsic, unalienable rights we have, it is the right of the people to alter or to abolish that government and to institute new government, with the new government laying its foundation on such principles and organizing its powers in such a form as to them, meaning the people, shall seem most likely to affect their safety and happiness. That's not many words, and that's a lot of power packed in. I mean, again, it's worth it. We hold these truths to be self-evident, clear, that all men are created equal. That thought is unprecedented. In the large majority of human beings who ever have lived under some form of tyranny, some form of authoritarianism. So this sentence, we hold these truths to be self-evident that all men are created equal. They're not some lords and some vassals and some indentured servants. There's not a caste system, C-A-S-T-E, as there is in India, for example. And I'm not bashing any other country. That's why this sentence is so profound. We hold these truths to be self-evident that all men are created equal. And not only are they created equal, they are endowed by their creator. No doubt, someone created this, the creator, with certain unalienable. They can't be taken from us. We can't give them away. They can't be stolen. They can't be ripped out of us. They are unalienable and exist in us based upon, by virtue of our being human beings, with certain unalienable rights, that among these are life. I mean, is that not obvious? You'd wonder in this country, with the abortion issue we have today, that's one I always struggle with. The right to life. We don't have it with the widespread abortion we have, but I don't mean to get off on that. Life, liberty, meaning inherent freedom, autonomy, the right of me to self-determine my own life, the right of self-determination. Life, liberty, and the pursuit of happiness. Not that we're guaranteed happiness, the pursuit of happiness. And then that to secure these rights, governments are instituted among men, deriving their just powers from the consent, they have to have our consent, of the governed. That whenever any form of government becomes destructive of these ends, it is the right of the people to alter or to abolish it, and to institute a new government that will protect these transcendent principles that we laid out in the first sentence. Life, liberty, the pursuit of happiness. We're all equal. And we're all created with certain unalienable rights. Those things, when a government becomes destructive of those things, we're going to alter it or abolish it and create a new government. And we're going to make it protect us and validate those principles, vindicate those rights. And we're almost finished. I think we have 3 minutes. We're going to go on and finish this, but even though we think we know about the Declaration, you have to go back and you got to tear it apart. You got to think of Thomas Jefferson. They gave him 17 days to write it. He took about 2. He was writing with a quill pen and I'm sure a few candles, probably in a hot room. And he sat there, and I believe he was inspired. I think the Holy Spirit came to him because these, and Jefferson was a brilliant person himself, but these principles are unprecedented. To say that we hold these truths to be self-evident. They're not just kind of rights we have, sometimes, maybe. They're self-evident, that all men are created equal. That alone, and that we're endowed by our Creator with certain unalienable rights. We will pick up and finish the Declaration of Independence. Please, I hope you took notes. Look over those notes. Look over constitutional interpretation, statutory interpretation. And we'll pick back up with Thomas Jefferson in about a day and a half writing this instead of the 17 days he was given. It's so tight. It's so precise. I mean, it reminds me of the Gettysburg Address. One speaker who spoke for 3 hours at the Gettysburg Address told President Abraham Lincoln that what he said in 2 minutes was more powerful in Lincoln's Gettysburg Address than what the man who was talking to him could say to the people in 3 hours. That's how I view the Declaration of Independence. It's so precise, it's so concise, and it's so powerful because what it represents is a view of human beings and human life and government that had never been, ever, and still have, like we do it. So we have 1 minute left. I sure hope this whole time you have been listening and we didn't have a malfunction and I've just been talking to myself. I hope that you enjoyed this, and we will pick back up with Thomas Jefferson using his quill pen and probably 2 candles on some parchment, knowing I better not make a mistake because I can't scratch it out. I will have to start the whole thing over. And then beginning, when in the course of human events, it becomes necessary. We'll pick back up there, ladies and gentlemen. Thank you for joining in. I'm proud of you. You should be proud of yourself. We did some straight up constitutional law tonight, and then we went into the Declaration of Independence, and we will finish it in the next session in 2 weeks. So please join us. Please send a check so we can be sure and keep the webinar going. And I will see you soon.